for your patience. I believe we are up and live streaming on YouTube once again in order to maintain public access and open courts. This is Associate Judge John Lockwood of the 2nd Region Child Protection Court, number 1, Liberty County. Today we are conducting this hearing virtually via Zoom and live stream on YouTube pursuant to Texas Government Code sections 2.4.017 and 7.4.094. As of late yesterday afternoon, my understanding is after the coordinator has contacted counsel, there were no objections to proceeding virtually. Is that correct? If there,
it's correct. It's correct that
right.
There's no objection to proceeding virtually, but I am objecting to proceeding at all. I got notice yesterday, and so and I was in court all day, and I would say not only was it not adequate legal notice, but I didn't have adequate time to prepare with my client either.
Okay, let's go around and take announcements. Ms. Dick.
The department is ready, Your Honor. I do understand that Ms. Iverson did not receive notice and was not aware that the date had been changed, I believe.
Right, I believe the date was changed on Friday, correct? The 6th?
That's correct.
After, that would be after I'd left the courtroom.
Right,
And,
right. All right, thank you. Ms. Moore?
I'm ready, Judge, but I don't think that we can proceed without proper notice to Ms. Iverson.
Thank you. Ms. McGee, your announcement.
Yes, Your Honor. Same. I'm ready to proceed, but I certainly understand Ms. Iverson's position, and so I'm not opposed to her request for a reset, Judge.
Are the respondents together as a couple, Ms. Brown and Mr. Broughton?
No, sir.
And they share the child, Jacob, correct?
Yes.
Yes, sir.
JB. Right. What objections, if any, would you have in going forward today as to the mother? This is not our first or second, or I don't think third request for a reset. So we're not without guidance and timelines. So any objections as to going forward only against the mother, Lindsey Brown?
Yes, Judge. I think we need to go forward on these cases at the same time. Especially if the department thinks it's going to take more than an hour and a half. I don't see what the benefit is, even judicial economy wise, for the county to pay for everybody and have space in the courtroom or in the calendars to do all this more than once.
Ms. Moore, let me worry about that. Okay, I'll worry about that. This case has been pending far too long. I think we can agree on that. I'm sure some of you would say it shouldn't be pending at all. Some would say, I'm sure. So I do believe one of the dates to which to continue this hearing from last Friday was October the 20th. I don't think it was good for your client, Ms. Moore. I think she was going to be out of town at a show or something. So has that changed? Do we know?
I don't believe that's changed. If you wanted to go forward on the mother today, again, I would have to have the father here and take his testimony, and I think that would.
Well, I've all but decided against that. So what about Ms. Brown, you appearing virtually on the 20th?
Your Honor, I'm going to be at a horse show, and at the time frame that y'all would be requesting me to be able to join even virtually is pretty impossible.
Well, I don't think this time around we've discussed an actual time frame. Given what we already have on the 20th, I might look to the afternoon of the 20th, and I really don't recall any other conflicts as that there might be since then. So how would the afternoon be?
At this time, I'm not totally positive. We don't have a schedule for each individual day of the show. I'm out of town from next Tuesday through Sunday, basically.
Okay.
Oh, there was something else. My other case was maybe Rodriguez after I left was set for the 20th. I can't do the 20th for either.
Okay.
Could we do the 16th? Is that out?
I can do the 16th.
Well,
I don't know, Judge, your calendar.
I'm working with different screens here. My mind goes to Hardin County on the 16th. I know we have a full docket on the 17th. Ms. Moore, you might be able to tell me quicker than my computer here. Do you have anything on the 16th in Hardin County?
No, I was going to say I was supposed to be on vacation, but I'm not. I don't even see a docket online on the 16th. I do see a docket online on the 17th.
That's
Yeah, and yeah. Okay. Well, Ms. Iverson and everyone else, Ms. McGee, you have something on the 16th. It looks like. Let me guess, a jury trial. No.
It actually is, Judge. You guessed right. However, we think we have an MSA. However, the father is incarcerated in Montgomery County Jail. We have not been able to obtain his signature as of today. We do have pretrial conference tomorrow. I'm hoping it will all be resolved by then. But as of right now, I am scheduled for that jury trial, October 16th in CCL 3.
Okay. So is it fair to say that you may know a little more after tomorrow's docket?
Yes, that is very fair, Judge. And there is one other thing, Judge. I actually had 2 conflicts that morning. I'm also set for a bench trial in the 410th for an adoption that may or may not go away as well, Judge. So I still probably couldn't make it to Liberty before 11 a.m. probably.
Well, let me ask you all in that regard, will your all the attorneys, will your not objecting to this hearing being held virtually pursuant to the aforementioned statutes apply to any continuance, say, for example, to the 16th?
Can I get clarification?
Yeah.
You're asking for the entire hearing to be on Zoom, or will we object to Ms. McGee? Because I don't object to her being on Zoom, given her situation, but I do think that I would like to be present with my client so that she can communicate with me much easier during the hearing. Otherwise, she's going to have to text and also be on camera, and it's going to be frustrating. Now, I can meet with my client at the courthouse and we can log in on Zoom that way. We wouldn't have any objection if the court allows that.
Or just, you could meet anywhere and just get on together, really.
Well, we do have some history and experience doing it that way. Let me, bear with me, let me see if we can even get a courtroom.
Well, that's not necessary, Judge, because if everybody else is going to be on Zoom, I can do it from an office, an attorney's conference room.
Okay. Well, let me ask Ms. McGee, does that help you out a little bit?
It does, Your Honor. I definitely think that, especially if the jury trial goes away, I'm pretty sure I can be on Zoom shortly after at 9 o'clock.
Okay. All right. Thank you. So again, to be clear, this would be for the entire hearing. And I would like, since this seems to be somewhat protracted hearing, I would like us to start at 9 instead of 1:30. And you all would be the only case that day at this point. So, Ms. Dick, I've not heard from you for a minute.
I have no conflict that day. I'm happy to start at 9, 8:30, whatever works for everyone.
Okay.
And we are still talking about the 16th.
I'm
Yes.
sorry. I'm sorry, Ms. Iverson.
I just want to clarify, we are still talking about the 16th.
Yes, ma'am. The 16th, Monday. I just feel like I think once upon a time I had something set for the 16th. I don't see it. I guess it went away. Okay, with no objections to doing the motion to participate virtually, then I won't need to look for a courtroom in this instance. In fact, I believe we're still looking for one for the 20th, and now I know, Ms. Iverson, that date is not good with you. If you don't mind terribly, just shooting a one sentence email to Ms. Wallingford and telling her as much?
I did, but it was easily probably lost in the chain of text,
right.
of email. So I will fix that.
Okay, all right. Thank you so much, and we'll take a look at that and regroup. Family and Protective Services versus Jacob Broughton and Lindsay Brown. The court will note that Ms. Brown is present virtually, as this docket is virtual. And let me call again for Jacob Broughton. Jacob Broughton. Jacob Broughton. All right. I don't see the name, no answer, nor is anyone presently in the waiting room. Let me make sure we have Ms. Moore and Ms. Iverson and that they can hear me.
Yes, sir.
Okay, all right. All right, thank you all very much. Is there a request? We'll start with Ms. Dick and go around, Ms. Moore, Ms. Iverson, Ms. McGee. Is there a request for opening statements?
Yes.
All right.
I'd like to invoke the roll, Judge, if possible.
All right, so the rule has been invoked, and what that means basically, but very importantly, is that witnesses may not be privy to other witnesses' testimony. They will need to be placed outside of the virtual courtroom and will also be precluded from viewing the proceeding, hearing another's testimony by way of YouTube. What it also means, again, very importantly, is that witnesses, while this is pending, may not talk about this case with anyone, save and except an attorney on the case. So does everybody understand the rule? Ms. Dick, if you will let me know who your department representative will be and your first witness, I will leave them in the courtroom and place everyone else outside of the courtroom who's not a party, the first witness, or necessary to the court's work.
All right. Tracy Mays is my department representative, and I will call the mother first.
Okay.
Thank you. This family has been involved in a CPS investigation or case since the child was born, with the exception of a few months between the dismissal of the first family-based safety services case in March of 2023 and the investigation that started again in June of 2023. Their child, Jacob Michael, has been living with friends or fifth kin for the majority of his life. And the department is, has evaluated the overall situation and have determined that the risk is quite high. And we believe of harm to this child is quite high. And we believe that the evidence will show our concerns effectively. And we're asking the court to understand that there is prior history in this case that we will need to present. And we do have a number of witnesses that will be asking to testify as a result. But the behaviors and the patterns essentially haven't changed. That's our concern for this child. Thank you.
All right, thank you. Ms. Moore.
Judge, I believe that the evidence will show for my client that she has tested negative for substance abuse. She has provided to the department a letter from Tri-County Behavioral Health showing that she does not qualify for services, that she has a stable home, that it's clean and it's appropriate for the child, that the only reason that this is a court-ordered services case is because the department's FBSS department doesn't want it. So investigations is trying to force this case onto FBSS. She's already worked services. She is asking for this child to come back home to her. There's been a safety plan in place for the child to be with a friend. She has been significantly involved in the child's life while he's been over there. We don't believe that there is a quite high risk of harm to the child, and we would be asking for the return and a dismissal.
All right, thank you. Ms. Iverson?
Very briefly, Judge, because I would basically echo everything that Mr. said, but I'd add to that, the beef that the department has with my client is basically that he's not participating in services fully on their time. But I would also add that the parents are not together. There's no intention to be together again. They do not reside together, and we're asking that the child be returned to the mother. Nothing further.
All right, thank you. Ms. McGee?
Yes, Your Honor, thank you. Your Honor, I am aligned with the parents this morning on this issue. I disagree with the department that there's a, what did she say, quite high risk. I understand that the mother has worked services for the department within the past year, and I also disagree that that the patterns are still the same. The child was placed back with this caregiver even before CPS got back involved, that the mother took it upon herself at a time she was still with the father, and there was a situation she felt the need on her own to get the baby out of that situation. And so to me, I think that that speaks volumes of her parenting abilities and her ability to protect her child. I've been in contact with the placement caregiver who has expressed no concerns, does not see these patterns, has confirmed that the parents are not together. My understanding that they she's going to continue to be a support for the mother and will be there available if another situation arises, Judge. And so I'm aligned with the parents, Judge, that the department's request should be denied today.
All right, Ms. McGee, thank you. Then, Ms. Dick, you may call your first.
Yes, at this time I'd like to call Christine
Proceed.
Wade. Okay, Ms. Wade, how long have you known the mother, Lindsay Brown?
I used to work with her about 10 years ago. And then I recently got back in touch with her during her pregnancy with the baby in question.
All right. And have you tried to be a support to her in her sobriety?
Yes, ma'am.
And how has that worked over the last 10 years?
I was not in contact with her between working with her and when she was pregnant.
All right, just a moment.
So,
just a moment, Ms. Wade. Hold on just a moment.
okay.
I believe you're objecting to relevance, Ms. Iverson. Is that correct?
Yes, sir. Of the time that we're talking out about basically a newborn here, and we're going back 10 years when she had no children, or if she did, they're not the subject matter of this case.
All right. So the court's going to sustain that objection.
And Your Honor, I would just say again that we're showing patterns of behavior over periods of time, and this is one of her friends who's known her for 10 years.
I'm not sure that a decade is relevant. So if you want to narrow the time frame.
Thank you. All right. Prior to the baby being born, were you in contact with the mother?
No, I worked with her briefly 10 years ago, and then she got back in contact with me after she got pregnant with the baby.
All right. And after the baby was born, did you assist Ms. Brown?
Yes, I would go get the baby anytime that there was any kind of, I can't do this, I'm too upset to handle him. Yes, ma'am.
Okay. And did you, based on your observation, what were the concerns that she was having at that point?
I'm going to object to speculation.
Overruled. You may answer.
It was I seen more of relationship problems and new mom issues. She just get overwhelmed with the baby crying and things like that.
How long did she care for Jacob Michael?
How long did I care for him?
Yes. Did he actually move in with you at one point?
No, he did not live with me, but I would have him sometimes 2 and 3 days at a time.
All right. And when did you stop seeing the baby? When did that caretaking stop?
When CPS removed him from Lindsay and Jacob Broughton.
And did you have any contact with Jacob Broughton during that time?
And passing bys, hey, how are you type situations, but no, I don't know him personally.
Okay. As her friend, did you have concerns over his behavior?
Of his behavior?
Correct.
I had concerns with both of their behavior towards one another.
And what were your concerns?
There was a lot of bickering back and forth, and I know how fast that can escalate. So I was concerned with those issues.
Okay. And did you have concerns over Lindsay maintaining her sobriety?
I had issues with when they would argue.
Objection, non-responsive.
Sustained. Sustained. Listen very closely to the question and answer only what you're being asked. Thank you.
Did you have concerns over Lindsay maintaining her sobriety?
Then or now?
Then
I did, yes.
Can I get a time frame on that then?
This was the first case.
What's the time frame? Years, month?
This is whenever CPS removed the baby the first time.
And did you maintain contact with Lindsay during that time period while she was
Yes, ma'am.
receiving services?
Yes, ma'am.
Okay. And were you aware of when she went to Santa Maria?
Yes, ma'am. I dropped her off.
And did you know why she left Santa Maria?
Objection
did
call
not-
for speculation, hearsay. Unless the
Well,
mother told her.
sustained unless the mother told her why.
The only thing I was told was she did not call me because she knew I would disagree.
And did the mother tell you that?
Yes, Lindsay Brown told me that she did not call me to come get her because she knew I would disagree with her leaving treatment.
All
And
right.
do we know a time frame on this?
It was September of last year.
Of 22.
Yes. Right
Okay.
around my birthday. She missed my birthday.
Okay.
Did Lindsay Brown ever talk about Mr. Broughton's sobriety?
I knew he had struggled with it for several years before.
Non-responsive.
Sustained.
Did Miss Brown state to you that Mr. Broughton,
Objection, assuming facts not in evidence.
Overruled.
Objection, counsel testifying.
Overruled.
did Miss Broughton indicate to you that Mr. Broughton was using drugs?
Objection leading.
Overruled.
Speculation to the degree it might.
Overruled. I would need a time frame, however.
So since this case has been opened, I have not really been in contact, so I can't answer on this case.
All right, next question. Next question.
Okay. Did Ms. Brown ever tell you during 2022, when you were in contact with her, that Mr. Broughton had been physically violent toward her?
No.
So she never implied that he had or indicated they had.
Objection asked and answered.
Sustained.
So since this case has been open, are you saying you've had no contact with Ms. Brown?
No, I've had very little contact. I got a new job working at the school district, and with my kids and my job, I don't really have a lot of time for friends right now.
All right. No further questions. I'll pass the witness.
Thank you, Ms. Moore.
Did she live last year in the same place that she lives this year?
With the last case or last year?
Last year. Or last year. Well, yeah, last year. Let's go last year.
I want to say they spent Christmas there. Yes.
Okay. Have you been there?
Yes.
Is it clean?
Yes.
Is she generally a good housekeeper?
Yeah, she stayed with me briefly and she kept my house pretty clean for me.
Okay. Now, you made this statement in your previous testimony that you had concerns about her sobriety then, talking about the last case, right?
Yes.
But now, do you have concerns with her sobriety?
No, ma'am.
All right.
Ms. Moore, excuse me. Before we get much further along, when Ms. Wade, you said a year ago, they lived there. Who all do you mean by they?
At Christmas time, her and Jacob Broughton lived in the home.
Okay, so Christmas 2022?
Yes.
And that's the same home in which the mother presently lives?
Yes, that's where I dropped off Christmas decorations I donated to them.
All right, thank you. All right, sorry, Ms. Moore, you may continue.
That's okay. Now, you said that when she had this baby, that there were moments that she would feel overwhelmed as a new mom. Is that right?
Yes, ma'am.
Do you think that it was an appropriate parenting decision to call help when she was feeling overwhelmed?
Yes.
And there were times that you would keep the baby for 2 to 3 days to allow her to have a little bit of a break. Is that right?
Yes, ma'am.
You weren't keeping the baby 2 to 3 days all the time, were you?
Not all the time, no, ma'am.
It was occasionally if she needed a little break.
Yes.
To sleep.
Sleep, shower, eat a meal while it's still hot.
Okay. Are you a mother?
I am definitely a mother.
So you understand what it's like when you have your first baby, right?
Yes, ma'am.
And you're tired and you're not sleeping, and there's a lot of new things that you have to learn, right?
Yes, ma'am.
And you were there to be a good support to her.
Yes, ma'am.
Did you ever feel like during that time, or you didn't ever feel like she abandoned this baby? Did she?
No, ma'am.
Okay. It was simply her asking for help.
Yes, ma'am.
Is that what you would encourage new mothers to do when they feel overwhelmed?
Absolutely.
Did you yourself reach out for help when you felt overwhelmed as a brand new mother?
Yes, ma'am.
Have you ever seen her do anything that made you have concerns about her ability to be a mother?
No, ma'am.
Did you ever see her hurt the child?
Absolutely not.
Did you ever see her do anything that you felt like could have led to maybe an unintentional hurting of this child?
No, ma'am. That's when she would call me when she would reach a point of
Okay.
breaking.
And you said that sometimes the feeling overwhelmed was also due to the bickering in the relationship. Is that right?
Absolutely.
Do you think it's a good decision as a mother, if you are bickering with the person that you're with, to remove your child from that situation?
Absolutely.
What was she doing for work last year?
She's at the same job. She's now, she handles horses, feeds, and takes care of horses.
Okay. So she has stable employment. She's had it for quite a while, correct?
Yes, ma'am.
Do you know how long she's had that employment?
I would say almost 1.5 years now.
Okay.
But prior to this location, she was at another location doing the exact same work.
For the same person or someone different?
Someone different.
Okay. I'll pass the witness.
I don't have any questions for this witness, Judge.
Okay, thank you. Ms. McGee.
Just briefly, Your Honor. Miss Wade, do you have any reason to believe that Lindsay's baby would be in any harm if he were returned to her today?
No, ma'am.
Thank you. I'll pass the witness, Your Honor.
All right, thank you. Back to you, Ms. Dick.
Ms. Wade, the prior attorney, you mentioned bickering. Would you characterize the arguments that the mother and father had as mere bickering?
Objection unless she witnessed the argument.
Well, sustained unless she witnessed it or one of the parents told her.
The biggest thing I can remember is things like, who are you talking to on the phone? That's not really your dad. Why can't you help me unload groceries? Nothing too major. I mean, something I'm sure every relationship's had some kind of argument over.
Did you approve of her relationship with Mr. Broughton?
Objection, relevance.
Sustained.
Okay. As a close friend, well, let me just clarify again. You said that you haven't had as much contact with her over the last year, correct?
Since this case got opened, actually.
All right. What about in January of 2023?
I was around.
Okay. And what happened in January of 2023?
All I know is I got a phone call. And I went and I showed up at her house. The house was a mess. There had been some kind of altercation, whether he destroyed her property, she destroyed his. I'm not sure.
And what did you do when you arrived?
I had to call 911
Why?
because she had gotten upset and took too many of her medication.
Okay. And was Mr. Broughton there?
No.
All right. And did you go to the hospital with her when 911 took her in?
They wouldn't let me.
All right. And do you know how long she was in the hospital?
She was there for the 48-hour hold, and then they sent her to Kingwood Pines.
And how long did she visit her at Kingwood Pines?
She refused visits, but I did drop off stuff for her.
Were you able to talk to her at all?
She called me.
And what did she tell you had happened?
Just that she had accidentally took too much of her medication.
And
that she was sorry.
And did she tell you why?
That there was some accusations that she was seeing somebody else.
And were those accusations from Mr. Broughton?
Yes.
Objection calls for hearsay.
Did the mother tell you that?
Yes, ma'am. Yes, sir.
All right, overruled.
Did you see Miss Brown after she was released from the hospital?
Yes, ma'am.
And did you have concerns for her at that time?
I'm always going to be concerned. But I feel like she came out with a better head, better grip on it.
Okay. Your knowledge, did she seek any treatment after that?
She had done talk therapy for a little while.
And is this what she told you, that she was doing talk therapy?
She was looking into also Tri-County as well, if I'm not mistaken. That's what she said.
Right.
And again, Ms. Wade, this is still January of this year?
Yes, sir.
Okay. If you know, when she was discharged from Kingwood Pines and returned home, was Mr. Broughton in the home at that time?
If I'm not mistaken, that is when she put him out and there was no more contact.
Next question.
To your knowledge, has Miss Brown sought any treatment or any ongoing support for drug issues?
Objection, hearsay and lack of personal knowledge unless my client told her.
Well, is there anything within that question that the mother told you, Ms. Wade?
I know she was trying to get into Tri-County and she had reached out to me a couple times, but like I said, I just started a new job and I didn't have time.
So this was recently?
Yes, ma'am.
Okay. And during the course of your friendship, has she ever indicated to you that she attends AA or NA?
Not since the baby has been born.
All right. No further questions. I'll pass the witness.
All right, thank you, Ms. Moore.
I want to talk to you about that incident from January of 2023 when you showed up at the house. The baby was not in her home, was he?
No.
at that time, the baby was living with Nikki. Is that correct?
Yes, ma'am.
And that's because the other CPS case was still open, correct?
Yes, ma'am.
Okay. So at no time during whatever took place that caused the house to be a mess, or whatever argument happened that caused her to kind of have a little bit of an emotional situation, that baby was not present for any of that, was he?
No, he was not.
Now, based on what you know of her, from the beginning of her calling you when she feels overwhelmed, if that child had been in the home with her, do you believe that she would have been appropriate and called someone to take the baby out of the home while she resolved the situation? I'm sorry?
She would have called me.
Okay. And would you have been able to help?
I will always go get him if that's an option.
Okay. Now I know that you've said several times that you were working a new job and you didn't have time. So if this case were closed and this baby went back with her, right now, what is your schedule if she were to call and need help with something? Are you available? I mean, obviously it's going to depend on time and day, but are you more?
If I am not on a bus route, because I am a bus monitor, someone has my vehicle and can go get him for me.
Okay. So you're always going to be there as a support?
Always, for the baby.
Okay. Pass witness.
All right, thank you. Any other questions from anyone for Ms. Wade?
No, Your Honor.
All right, thank you. May this witness be excused.
Yes. I would say subject to recall, but I'm not sure that she's going to be available, but I do want to thank her for coming.
All right. So Ms. Wade, the court is going to excuse you with its appreciation for your time and your assistance in this matter.
All right. Ms. Johnson, were you the investigator for the most recent investigation in this case?
Yes.
Okay. And when was that investigation? When did that begin?
On or around June the 12th this year.
Okay. And what were you investigating?
The report came in for neglect.
Objection, hearsay.
Okay. So based on, all right. When did you first meet the mother? I'm sorry, Ms. Johnson.
I do not remember the initial dates.
Okay. And
it was June.
Okay, so with June 16th, around June 16th.
It was near the end of the June though.
Right. When you met with her, did you ask her what had occurred between her and Mr. Broughton?
No. Not when I met with her.
All right. So when did you first discuss the incident that occurred in June with her?
Closer to June 20th.
All right. And did you meet with Ms. Brown and Mr. Broughton at that time?
No, my initial contact was over the phone.
All right. And were Mr. and Miss Brown and Mr. Broughton together at that time?
Objection calls for speculation unless they told her they were in a relationship.
Sustained unless one of the parents told you.
No, I don't remember them exactly saying that.
All right, sustained.
Okay. What type of incident were you investigating?
Objection, hearsay.
Overruled.
Concerns of substance abuse by Ms.
Objection, hearsay.
Overruled.
Concerns of substance abuse by Ms. Brown.
Okay. And did you ask her to drug test at that time?
Yes.
And what was her response?
She agreed to drug tests.
And when was that drug test set up?
It was set up maybe the 17th of June, on around.
Okay, did she follow through and do the drug test?
She only agreed to do the urine test.
And did she provide a reason why?
Later, she did.
All right, and was Mr. Broughton asked to drug test too?
Yes.
Okay, so when did you meet with the parents again?
June 20th, I met with the mother.
Okay, and at that time, what did you discuss?
The next stages of the case and also the visitation agreement.
Okay, and what was the visitation agreement?
That the visits will either be held at a CPS office or at a approved caregiver's residence by an approved caregiver, and that she would, if transportation was needed, she would have to inform the agency, and that she has to confirm the visits 24 hours prior to the visit.
Okay, and was transportation needed at that time?
Yes.
Why?
She informed me that she had no transportation.
Was she living with Mr. Broughton?
Objection,
No.
hearsay, or speculation.
Sustained unless she observed or one of the parents told her.
She told me no.
Okay, so that was in June.
Yes.
And between June and July, did that situation change? Well, let me clarify, sorry. Okay. They were not living together, correct?
Right.
Were they still together as a couple?
Objection, speculation, unless she was told by the parents.
Is that something the parents told you, Ms. Johnson?
Yes, they told us no, they weren't together anymore.
All right.
Okay. And then in July of 2023, July 5th of 2023, did you speak with the mother again?
Yes, we spoke during visits at the office, and we communicated on the phone.
Okay. Did she express any concerns about Mr. Broughton to you at that time?
Yes. She finally admitted to domestic violence by Mr. Broughton.
All right. And did she say what had occurred?
She wouldn't go into detail because there were only certain times she could speak, and she wouldn't go into detail. She just says that it was physical violence.
All right. And why wouldn't she go into detail? Did she say?
There were times that she contacted me when she felt comfortable and safe to contact me, meaning he wasn't around. But she did not say why she didn't want to go into full detail, no.
All right. Was a family team meeting held with the mother and father and Nikki Monso?
Yes.
Okay. And during that family team meeting, was domestic violence addressed?
Yes.
All right. And how did Mr. Broughton respond to that?
He didn't agree that there was domestic violence.
Did he ever acknowledge that during that meeting that that domestic violence may have occurred?
Objection, asked and answered.
Overruled.
Yes, he eventually admitted that there was domestic violence.
Okay. And what did you ask parents to do at that point?
Can you repeat your question?
And what did you ask the parents to do at that point, at that meeting?
I don't remember we asked them anything to do. We had to staff the case. So at that point, I didn't ask them to do anything.
Okay, did they agree to work services?
Yes.
All right. Did Ms. Brown or Mr. Broughton indicate they would be willing to submit to a hair follicle test?
No.
All right. How did Ms. Monceau respond to this situation? Did she?
She was comfortable with baby Jacob still residing with her while the parents worked services through the department. She was not comfortable with having visits.
Judge, are we talking about the mother or are we talking about the placement?
It sounds like we're talking about the placement, Nikki Monceau. Is that correct, Ms. Johnson?
Yeah.
Objection, hearsay.
Sustained.
Okay. Did Ms. Monceau, well, where was the child going to be placed during this period of services?
Well, it wasn't a placement, but the parents agreed to allow the child to continue to reside with Miss Nikki.
Okay. Were there any subsequent concerns about the child staying with Miss Nikki on the part of the department?
Yes, we had concerns if the placement was going to sustain or break down.
Okay. And at any point in time, did the parents pick up Jacob?
I'm sorry to interrupt. I apologize, Ms. Dick. My client's in the waiting room again.
All right. I do not see the name. Can you give me the last three of his phone number? All right. Mr. Broughton, is that you?
Yes, sir.
All right. Thank you. I have you marked present. Are you able to turn on your video?
No, sir. I'm having video trouble.
All right.
That's why I had to.
All right. I have you marked present. If you will go ahead and mute yourself and we'll continue. Thank you. You may continue, Ms. Dick.
Okay. So at that point in time, what was the visitation plan for the parents with the baby?
It was supervised visits by CPS or approved caregiver at an approved location. Yes.
Okay. And were the parents following that plan?
Ms. Brown was the only one visiting.
Okay. At any point in time, did the parents pick Jacob up from Ms. Monceau's?
Can I get clarification? Are you speaking about
July, before supervised, or July before the supervised visitation at the department occurred?
Yes.
All right. And so what was the department's response at that point to the situation?
Well, when we were notified, the child was returned already to Miss Nikki's care. And then we stopped and put in the visitation plan.
And what was the new visitation plan?
Repeat that?
What was the new visitation plan?
No, there was only one visitation plan.
Okay, so what was that visitation plan
The
then?
visitation plan was with the mother was supervised visits by approved caregiver CPS at approved location. And if transportation was needed, she was to notify the department, and then also visits had to be confirmed 24 hours prior.
And what about the father?
We were never able to arrange visits with him.
All right. And why was that?
He went missing for a certain point, and then once he got back in contact with me, I went over the details of the visit, as I just stated, and I asked if he had a supervisor. He provided the supervisor. We did all the necessary things to get the person approved. He provided the days or dates he wanted to visit. That became a conflict, and he became hostile, and he didn't want to communicate with myself any further.
Okay, what was he asking for in terms of visitation?
He was asking for 3 days a week in the evening.
All right, but that's when the child was, that was when Miss Nikki was still supervising the visitation, is that correct?
Yes, but she was not going to be the one supervising.
I see. All right. And when did the visitation shift to the ACPS office?
It's always been at the CPS office.
Okay, but you were trying to arrange for a separate visitation for Mr. Broughton?
Yes, due to his work schedule.
All right. Has Mr. Broughton visited the child? When was the last time he visited with the child?
I don't know.
Would it be safe to say it was in July?
Objection, she stated that she does not know, so that would be speculation.
Sustain.
All right. What was the next step in this case?
The next step was for the family to engage in services with family-based safety services.
All right, and what happened with that step of the case?
Ms. Brown and myself and a family-based safety service caseworker, a joint visit at the end of July. I don't know the exact date. The end of the July, Ms. Brown agreed to work services. I explained the concerns of the case to the family-based services worker. Ms. Brown explained some of her history and the current situations. And that was it.
And what did she explain in terms of the history and her current situation?
She explained services that she engaged in the prior family-based case earlier this year. She expressed that she was not using any drugs. She expressed domestic violence that was occurring between her and Mr. Broughton. And she expressed wanting to work the services.
Okay. To your knowledge at that time, did Mr. Broughton have a place to live?
No, he told me he was living out of his car, their car.
Okay. And where was the mother living at that point?
She was living in her home in Cleveland.
Okay. Is that where the Staples is that she works for?
Yes.
Okay. What were the department's primary concerns about, well, what was the investigation's primary concerns about this case? And
it was regarding substance abuse by both parents, domestic violence, and the mother's mental health stemming from the domestic violence.
all right. And did you ask the mother if she had followed up with any services after she was hospitalized in January of 2023?
No, I didn't.
No further questions of this witness. I'll pass witness.
All right, thank you, Ms. Moore.
Okay. You never interviewed Miss Brown in person. You only spoke to her at visits and on the phone. Is that correct?
I personally never interviewed her.
Okay. Now you said that she agreed to take a UA test only, and she did take that test and it was negative, correct?
Correct.
And she expressed to you the reason she didn't want to do the hair follicle, didn't she?
Correct.
And that was because in the previous case, she was positive for drugs and she was afraid that it would still be in her hair. Is that correct?
That's what she said.
Okay. Now, after that initial UA, did you send her for any other UAs?
No.
Have you sent her for any hair follicles?
Yes.
And that was a recent one, correct?
Yes.
And she was negative on that test. Is that correct?
Yes.
Now, you talked about in July that they admitted to domestic violence. Now, at the FTM or the family team meeting, you guys talked about domestic violence and you gave them the definition of domestic violence. Is that correct?
No, I don't know if I did.
Well, someone from the department gave them the definition of domestic violence. Is that right?
Maybe.
Okay. And what is the department's definition of domestic violence?
There's not exactly a definition. That's why I'm not sure what you're saying. Someone gave her a definition.
Did the department tell parents that domestic violence could include physical violence? It could include emotional abuse or mental abuse?
Yes, those are concerns of domestic violence.
Okay. And after they were given that definition, isn't it true that that's when they said domestic violence based on that definition?
No, I remember that's when the father said confirmed.
Okay. Now, your concerns about domestic violence are between Jacob and Lindsay, correct?
Correct.
But Jacob is not in a relationship with Lindsay anymore, is he?
No.
Okay. And how long has it been since Jacob has lived with Lindsay?
I'm not sure.
Okay. Well, he told you in June that they weren't living together, right?
Okay.
That's what you testified to, is that right?
Yes.
So it's been since at least
objection, mischaracterization. I believe it was July.
Your testimony, do you recall your testimony that on June 20th, when you had a conversation, with my client, that she said that he was not living with her?
Yes.
Okay. So at least
okay, let me just, she's just mischaracterizing it because Mr. Broughton is the one that said that they were no longer living together in July.
Okay. So I'm not talking about July. I'm talking about her testimony from June 20th when she was having a conversation with my client. My client said that he wasn't living there. Is that right?
I really believe it was July.
That's fine. So since July, they haven't lived in the same home. Is that right?
Correct.
Okay. So then there wouldn't be a concern about domestic violence happening if they're not in a relationship and they're not living in the same home. Then how would domestic violence continue, right?
There were other concerns that he was very controlling of her, even with not being around.
Okay. Objection.
Unresponsive.
What's the question?
Overruled.
Is it part of the department's remedy when there's domestic violence in a case for the victim and the abuser to not be together?
That's one option.
Okay, and that will remedy domestic violence if they're not in a relationship and they're not living together, correct?
No, that won't remedy.
Okay, so then if they're not together, they're not seeing each other, they're not living together, then domestic violence can't happen because they're not around each other. Is that right?
It's the concern of the controlling.
Okay, if they're not in a relationship, there's not much of a concern for control, is there?
Yes, it is.
Okay, so when is the last time that you had a concern that he was controlling my client?
In July.
Okay, in July, which is when he moved out, right?
Right, but he.
So you haven't had a concern about him controlling her since July, is that correct?
Objection asked and answered. She's already stated that July was the last time.
Sustained.
Now, you said that they agreed to work services, or that my client agreed to work services, but you didn't set those services up for my client, did you?
I did. I did what my requirements are, which is.
Did you send 2054s for services?
That's not what I do in investigations.
Objection, non-responsive. Did you send 2054s to set services up?
No.
Did you ever, and you also didn't ever give my client any addresses or resources or phone numbers of places where she could set those services up, did you?
No.
Okay.
Objection, counsel testifying.
Overruled.
And you received an email on August 11th from me. Do you recall that?
Maybe.
Okay. And in that email, do you recall that I am recapping a phone conversation that I had with your attorney?
Actually, no, you did not send that to my right email.
Would it refresh your memory if I were to show you the email?
Sure.
Judge, may I share my screen?
Okay, let me enable that, and then you may.
Objection, hearsay.
Okay. Are you saying that that is not your email address?
Yes.
Okay. So there's another Ariel that works for the department.
No, I don't know, but that's not my email address.
So what's your email address?
.gov.
Okay, so that's your old email address.
Yes.
Okay, so that's my bad. Were you made aware that my client requested to be given that on August 11th that my client requested that CPS send her for UAs on a weekly basis?
Are you asking on that date? Was I aware?
Are you aware
Objection,
right
Your
now?
Honor, counsel is mischaracterizing it. There were subsequent
Objection.
conversations. She is taking a prior email and mischaracterizing what occurred.
Response, Ms. Moore.
I don't think that that's accurate, Judge. I'm asking her if she knew about something. I'm not trying to ask her about
Right,
this.
let's hear the question again.
Are you aware that my client asked for CPS to send her 4 UAs on a weekly basis?
I am aware.
Okay. Did you do that?
I was recently made aware.
Okay. When were you made aware?
Sometime last month. I don't know the exact date.
Okay. So it wasn't in August when that email was sent, right?
No, it wasn't when that email was sent. No.
Okay. Were you made aware that my client requested information for the substance abuse assessment, for a psychological, for therapy, and requested for the department to send 2054s for those services?
No.
Never you were made aware of that?
I was made aware of the email.
Again, I believe that counsel is trying to mischaracterize all the communication. She's leaving out part of the communication where she later indicated that they would not be cooperating.
Anything I later indicated.
Overruled. You may answer.
So you weren't aware of that at all?
No, I was aware.
Oh, you were aware about her request for 2054s?
Yes, but not when the email was sent.
Okay. At what point did you become aware that she requested the 2054s?
Sometime last month.
Did you send them?
One was sent. Yes.
Which one was sent? The one for the hair follicle?
Yes.
Okay. Now you talked about, and I want to make sure that I heard you right. Did you say in the month of July that my client went and picked up the baby and that the baby was with her and then you guys did a new safety plan?
No, there was only one safety plan that was done.
Okay. Did you say at any point that my client had gone and picked the baby up?
I didn't say your client. I said the baby was picked up.
Okay. The baby was picked up from who?
From Miss Nikki.
By who?
I don't know which parent.
By a parent?
Yes.
Okay. And that was originally the plan all along from the previous case was for my client to kind of ease into having longer periods of time, basically a transitional return. Is that correct?
Yes.
When my client came in to see the baby in July of 2023, you had a conversation with her on that date, and isn't it true that she appeared sober and happy?
She didn't appear to be under the influence. That's what you mean.
Okay. And she is well bonded with the child, and he was happy to see his mom, wasn't he?
She's well bonded, yes.
And he was happy to see his mom that day, right?
Yes.
Okay. Now she has a home, and that's a positive for her as a mother, right?
Correct.
The bills are paid and the home is kept up. Is that right?
Sure. Yes.
Okay. And she has support from her family, from her dad. Is that right?
I don't know about that support.
Well, that was discussed at the family team meeting. Do you not recall that?
I don't recall her mentioning. I know he has provided for her, but I didn't know it was they remain in contact and all that.
Okay. Would refresh your memory to look at the family team meeting notes? Or if
no.
I told you that those notes say that she has family support from her dad, he's out of
Objection,
town.
Your Honor, counsel's testifying.
Sustained.
Would you like to see the family team meeting notes to recollect to recall your memory?
No, I know her father was around financially.
Okay, Judge, may I share the screen?
You may. And Ms. Johnson, you said you know her father was what financially?
Financially for her. There financially.
All right, thank you.
Okay, do you see the family team meeting notes here?
Mm-hmm.
Okay, and isn't it true that her father is a support to her, but he's out of town a lot? He's available for anything she needs.
Okay.
Is that true? Was that stated?
Yes, that's what you're showing.
Okay, and it didn't state anything about financially. It just says for anything. Is that correct?
Okay, yes.
And isn't it true that at that family team meeting that Jacob said that if they ever get to the point that they feel like they're going to be unhealthy with the baby, that he and Nikki agreed that he and Lindsay agreed that they would take the baby to Nikki?
Yes.
And that's a good parenting decision, isn't it?
Sure.
And were you made aware that my client also went to Tri-County to have an assessment done?
Yes, maybe 2 weeks ago.
October 2nd.
Okay.
Did you get a copy of that document?
Yes.
Permission to share the screen?
You may.
And I'd like to offer into evidence.
Objection, Your Honor. There's no foundation. Nothing has been.
Okay.
No
Well, before I
foundation
offer
has been laid for this.
Before I offer it,
and there was no indication of exactly what occurred provided in that. I mean, during that evaluation.
Okay, well, I can respond as to foundation.
Nor was that what we had asked her to do.
Okay, how is this not hearsay?
It's hearsay.
All right, so the court denies the admission of this document. Next question.
Okay, so you have seen the document that she got from Tri-County, is that correct?
Yes.
And at this time, Tri-County is not offering her any services, is that right?
Objection, hearsay.
Just a moment. Ms. Iverson, are you still here?
Yes, sir. I was gone maybe 3 seconds. I don't know why it just disconnected.
Okay. All right. I show your number twice on the screen.
Oh, that's weird.
But so long as you can hear and we can hear
Yes,
you.
sir.
All right.
Okay.
Okay. So backing up, Ms. Moore, would you ask your question again, please?
To your knowledge, Tri-County is not offering services to my client, is that right?
Objection, hearsay.
All right. Sustained unless the mother told her.
You didn't ask my client to go to Tri-County and to get a mental health assessment, did you?
No.
But you also didn't set up a mental health assessment for her per your previous testimony, correct?
Correct.
So wouldn't it be positive for my client to have gone on her own?
Objection, counsel is testifying.
Overruled.
Wouldn't it be positive for my client to have gone on her own to get a mental health assessment to show the department?
If she knew what we were asking for, yes.
If she knew what you were asking for, only then it would be positive for her to have gone and gotten her own mental health assessment?
Yes.
Okay, so how would she have known what you were asking for?
Through going to engage in services and family based.
Services that you didn't set up for her, right?
And family based.
Services that you didn't set up for her, right?
Correct.
So she had no way of knowing what specifically that you wanted because you didn't set it up and you didn't give her resources, did you?
No, she had a way of knowing.
Okay, so then what would be her way of knowing?
Engaging in family-based safety services.
Okay. Okay. So you don't believe it's a positive or that it's proactive at all for my client to have gone and gotten her own mental health assessment?
I don't know what type of assessment this was. I don't know.
Did you read the assessment, the letter from Tri-County that you were provided?
It didn't specify.
Objection, non-responsive. Did you read the letter?
Yes.
Abstain.
Okay. Now, give me just a second. What's a VCC?
I don't know the full name for it, but it's basically agreement with caregivers and parents.
Okay, and what's its purpose?
I'm not familiar. We don't do that in our department. So
okay. Isn't it true that you spoke to my client on June 16th and you asked her if there was a physical altercation with Jacob and she said not really?
Yes.
Okay, and isn't it true that at the end of May, that's when Nikki and my client Lindsay started working that transition of getting him back into his home, right?
I don't know the exact date because I wasn't involved.
Well, if you put it in your affidavit, would that be true?
It would be from the previous case, yes.
Well, if you put in your affidavit on June 17th, 2023, that this is the information that you received, would that be true or not?
It would be true.
Hearsay.
Okay. And Jacob Jr. had gone twice and stayed with his mom. Is that right?
Yes.
And while he was staying with his mom, isn't it true that Miss Nikki, the placement at this point, would FaceTime and check on him every day?
Yes.
And she always checked him when he came home to see if there were any marks and bruises, right?
Yes.
And there were never any concerns, correct?
No.
And there were never any concerns that they were under the influence while they had him, correct?
No.
And she never had any inclinations that they were using drugs, correct?
No.
That's not correct?
No, she didn't have any inclinations they were.
Okay. And then you spoke on June 21st to my client and with Jacob. Well, scratch that. Didn't my client tell you that when she tried to re-engage in services in Montgomery County that the case was non-suited?
Yes.
Okay. You sent this case to Family-Based Safety Services, correct?
Yes.
Here in Liberty County, right?
Yes.
And they declined to accept the case. Is that correct?
Yes.
And that's because they had already worked services, right?
You would have to ask them regarding.
Well, you put in your affidavit it was because they had already worked services. Is that not true?
Yes, that is true.
Okay. And also because the child was safe, right?
Currently, yes.
Okay. So previously you said that my client would only know what it is that you guys were asking if she worked services and engaged with FBSS. Do you recall that?
Yes.
But FBSS in this county is refusing to work with my client. Is that right?
Yes.
So ultimately, this case that is now before the court is here because investigations is trying to force FBSS to take it, is in essence, because you believe that they need services.
Yes.
Pass the witness.
All right, thank you, Ms. Iverson.
Well, Ms. Moore was so thorough, I don't have much. Other than to say, when you say that my client disappeared, isn't that in fact that he was trying to contact you and you were not returning his communications?
No, we missed each other's.
Okay, then to say he disappeared is not fair. You're admitting right there that he was trying to contact you.
No, I'm
correct?
speaking in general. No, I'm speaking in general. We would miss each other's contacts, and there was a
Objection non-responsive.
Sustained.
You're admitting that he did not, quote unquote, disappear. He was trying to contact you, correct?
no.
You just stated that he was trying to contact you. Is that not the truth?
No, I'm speaking about prior to the period that he was not in contact with me.
I want to be clear. You just stated that during the time you said that he disappeared, you were missing each other, which means that he was trying to contact you, correct?
No, I'm not. I wasn't speaking about when he disappeared.
So then I'm going to go back to my original question. When you said that he disappeared, was he not in fact trying to contact you and not getting in contact with you?
No.
Objection asked and answered.
Sustained.
When my client told you in June that he had moved out, did you go to the house to see if this was in fact the case?
No.
When did you go to the house to see if this was in fact the case?
I've never went to the house to ensure he wasn't there.
If domestic violence is such a concern to you, and that requires that the adults be living in the same house, would that be worth your time?
I've made attempts and they've been unsuccessful.
You tried to visit the home.
Yes.
What did you do to try to visit the home?
I drove to the home.
But you just stated you never did visit the home.
Well, I'm not sure what you're asking then. I have tried to visit the home.
But you never did.
Asked and
What are
answered.
you
Correct.
asking?
Objection
Sustained.
asked and answered.
I'll pass the witness.
All right, thank you, Ms. McGee.
Yes, Your Honor. Thank you so much. Ms. Johnson, just to kind of go back over the timeline, you started your investigation in June of 2023, correct?
Yes.
Okay. And during your investigation, you discovered that the parents had just finished working an FBSS case, correct?
Yes.
Okay. And they had completed that case around March of this year?
Yes.
Okay. And was that the case? that y'all referred to was in Montgomery County?
It started. That's what they were speaking about. It started
Okay.
in Montgomery County.
All right. So who closed the case in March of 2023 in FBSS for these parents?
Liberty County.
Okay. And so from March 2023 until June, when the new investigation started, what actually happened with this child for the department to come back involved with this family?
A report was made regarding concerns of the mother using substance abuse again.
Okay. And so that would have been notated in your affidavit, correct?
Yes.
Okay. And so you recall that the intake was just that the mother had previous CPS history.
No, that was also included, but it was a concern that she was using.
Okay. So there was a concern that she was using at that time in June of 2023?
Yes.
Okay. And that's when you did send her for or urinalysis, correct?
A hair follicle and a urinalysis.
But she only took the UA, is that right?
Yes.
Did you talk to her about her drug use?
Yes.
And when did she say was the last time she used any drugs?
She didn't give me a date. She just said that she's been sober since her case.
Has been
I'm sorry,
what?
I didn't. Yeah.
Has been what?
Sober?
Okay, thank you.
Okay, so she had been sober since the FBSS case closed?
Yes.
Okay. And during that time, did you research or I guess go through the record to confirm what services she had actually done in the previous case?
Yes.
Okay, and what were those services?
There were mental health services that consisted of like evaluation, counseling with a psychiatrist. I'm sorry, did you say something?
No, I didn't.
Okay.
I'm
So
sorry.
counseling with a psychiatrist, and then drug and alcohol counseling as well.
Okay, and she completed those in the previous case?
She completed the initial.
I'm gonna object to calls for hearsay or speculation, as she wasn't the worker in the previous case.
Well, sustained unless the mother told Ms. Johnson.
No, she didn't tell me.
So you didn't have a conversation with her about the services she had completed?
I did, but we didn't go through every single one.
Okay. What did she tell you she had completed?
Parenting, a drug counseling services that involve like weekly sessions, and that was it.
Okay. And did you contact any of these providers just to get in some feedback on her progress in these services?
No.
Okay. And so, and also during your investigation, in your affidavit, you speak about that Mr. Broughton, the father, actually called in the report in June of 2023, correct?
Objection, hearsay.
The question again, please, Ms. McGee.
Yes, Your Honor. Ms. Johnson, in your affidavit, you refer to a statement made by Mr. Broughton that he was actually the one that called in this report, correct?
Okay, overruled. You may answer.
Yes, he did inform me that.
Okay. And he also informed you that it was a misunderstanding and that he should have spoken with Miss Brown first, correct?
Yes.
And they both denied the allegations in the report, is that right?
Yes.
Objection. Reading from a document, not in evidence.
Overruled.
And so you also testified, Ms. Johnson, that even after that, though, the parents did agree to work services, correct?
Yes.
And what were the services that you were requesting at that time?
It was domestic violence, and there was substance abuse.
Okay, so in July 2023, you were asking for substance abuse and evaluation, or?
Substance abuse, yes, evaluations, and to follow the recommendations.
Okay, are those still the services that you're asking for today?
Oh, and also mental health, but yes, those are the services.
Do you know whether or not she completed a psychological in the previous FBSS case?
I am not sure.
Did you ask the mother?
No, I did not ask her.
And did you review the case file from the previous FBSS case?
I did review, but I cannot remember if she did a psychological. I know she did some sort of assessment. I can't remember the particular name of the assessment.
Okay, so if she did complete one within the last year, why would there be a need for another?
To see any changes.
But how does that, I guess, relate to the reason that you're asking for it based on any type of abuse or neglect?
Because that will determine what services that she would need now and not what she was needing before.
All right, and so what are your current concerns?
The current concerns are domestic violence, substance abuse within the case, and the mental health.
Ms. Johnson, in your investigation, did you find that this child had been abused or neglected?
The investigation is still open, so.
Okay, well, have you found since June of 2023 that this child has been abused or neglected?
There's concerns regarding neglect.
Okay, what are the concerns?
The concerns are the child being present during domestic violence incidents or situations.
Do you have any evidence that the child had?
The parents told me that during a argument in July or June, they took the child back to Miss Nikki because of the concerns they were having between each other.
Okay, and so that was a protective measure that they took upon themselves to get the child out of the situation, correct?
Correct.
Right, so that wouldn't be neglectful because they took the appropriate step to protect the child, correct?
Yes, after the fact, yes.
I'm sorry?
Yes, after the fact.
What do you mean after the fact? Was it not happening during that time when they made that decision?
Yes, but it was ongoing, and that was just another incident.
And so, but the child has actually remained there since that argument, correct?
Correct.
By agreement, correct?
Correct.
And so if the mother took it upon herself at that time to get the child out of the home to protect the child, what reason do you believe she wouldn't do that again in the future? What reason do you have to believe that she wouldn't do that in the future?
I'm not sure. That's the only time it's happened.
That is the only time that it's happened?
That's the only time that the child's been taken back to Ms. Nikki's regarding that situation.
Do you know if there was another time that it should have happened?
I don't know the exact date of when the incident occurred.
Well, what incident are you referring to?
There was a argument or dispute when the case initially came in.
Are you talking about this case or the
Yes,
previous case?
This case.
All right. So you believe that there was a separate incident?
Yes.
Okay. And where did you get this information?
It would be hearsay.
Okay. And so what evidence do you have that it would be a substantial risk for this child to remain in the home with his mother? Risk of danger, I'm sorry.
Can you repeat that?
So what evidence do you have that this child would be in any substantial risk of any danger if he were to be returned to the home of his mother?
If Ms. Brown and Mr. Broughton will truly remain apart. I don't know how long that would be.
And you have testified that you don't have any reason to believe that they have been back together since July of this year, correct?
No.
Okay. And do you get any indication from Ms. Brown that she intends to resume a relationship or dating relationship with Mr. Broughton?
I haven't had any contact with her recently, so I don't know.
Okay. When was the last time you had any contact with her?
Maybe at the very end of July or early August.
Okay. So you wouldn't be able to comment on any continuing danger at this time, correct?
No.
All right. I'll pass the witness, Your Honor.
All right. Thank you. Back to you, Ms. Dick.
Okay. What type of contact are you allowed with Ms. Brown based on her attorney's instructions?
I haven't been able to speak to her at all.
All right. And when the parents told you initially that they were willing to do a urine test, but no hair follicle, did that concern you?
Yes.
Why?
Because that would be a concern that they may be using and they've used in.
What type of drugs are difficult to discern through a urine test?
Objection. Calls for expert testimony.
Your Honor,
Response.
this is something that this caseworker has to deal with day in and day out as an investigator.
Doesn't make her an expert, Judge.
Okay.
It certainly gives her the experience to indicate.
Sustained. Next question.
So from February of 2023 to July of 2023, to your knowledge, had these parents, did mom, to your knowledge, take a hair follicle in February of 2023?
Yes.
And so now it's July of 2023, correct? When you asked her again? Or was it June?
June.
Okay. But she refused 4 months later to take a hair follicle, correct?
Right.
And Mr. Broughton refused to take a hair follicle, period, correct?
Yes.
All right. You testified previously that mother admitted to physical violence from Mr. Broughton, correct?
Yes.
All right. And based on the history of this couple, did you have concerns that whether they were together or not, there were threats of physical violence?
Objection called for speculation.
Overruled.
Can you ask the question again?
Okay. Did you have concerns whether the couple was together or not, that there was a threat of physical violence?
Yes.
All right. And even if a couple isn't together, certainly there are times when one might ask for a protective order, correct?
Object irrelevant to this case.
Overruled.
Even if a couple is not together, there could be times when a protective order could be sought, correct?
Yes.
All right. And did you ever discuss a protective order with the mother?
Yes, I don't know the exact month.
And what was her response?
There was no response.
Okay. And to your knowledge, had the mother, did she let you know that she had done counseling for domestic violence previously?
No, she never informed the agency of that.
Okay. No further questions at this time. I'll pass the witness.
All right. Thank you, Ms. Moore.
Yes. You said that you had concerns of threats of physical violence. Has my client told you that he has made threats of physical violence to her?
I didn't hear the question asked that way.
How did you hear the question? Because I heard the question as, do you have concerns about threats of physical violence, whether they're together or not?
I heard the question as in like if there was a threat of it, not if one person is threatening the other. Like threat of concern.
Objection, Your Honor. Again, I think that counsel is mischaracterizing the questions.
Overruled.
So then your testimony is not that anybody has admitted that a threat of physical violence has happened. No. That's not what you're testifying to. You're saying you have a concern that there could be domestic violence, whether a couple is together or not. Is that what you meant?
Yes.
And that goes back to what you said earlier about somebody could be controlling. Is that right?
Yes.
Now, if for some reason there was domestic violence, with a couple who's not together, you've already coached my client on how to respond to that by getting a protective order, right?
What do you mean coached?
You've told her about getting a protective order, right? You've informed her, you've advised her.
Okay.
Is that correct?
Yes.
So you've already given her the tools that she would need if domestic violence occurred with them not being together, right?
Yes.
Okay. Now you talked about not being able to reach out to my client, but you haven't reached out to me, have you?
I don't reach out to attorneys.
Objection, non-responsive. You haven't reached out to me, have you?
No.
Okay. And so the only way to talk to my client is to go through me, right?
Correct.
And you could have reached out to me to try to set up a conversation with my client, right?
Yes, I could have.
But you didn't.
Correct.
So then when did my client tell you that she last used? And you said she didn't give a date, but isn't it true that she told you she had last used in February or March?
Yeah, but that wasn't a date.
Okay, so then her last use from her admittance was from February or March, correct?
Correct.
Okay. Now, when you were talking about the services that my client said that she had done, you said parenting, drug counseling, and you said services that are weekly sessions. What did you mean by that? Services that would be weekly sessions?
I said mental health.
Okay, so my client told you she did mental health as well?
Yes.
Okay, and then what are the weekly sessions that you said? Services that would require weekly sessions?
There was like drug
counseling.
Yeah, I don't know the exact terminology.
And she also did other counseling with someone, didn't she?
The psychiatrist.
I'm not sure, but she did some counseling aside from the drug counseling.
That's what I said.
Okay, so then she did parenting, drug counseling, individual therapy, and mental health services.
Mm-hmm.
Okay.
And was that a yes, Ms. Johnson?
Yes.
You were asked by Ms. McGee whether you could comment on continuing danger, and you said no. And right after that, the very first question that your attorney asked you was if you've been able to speak to her, and you said no, because I wouldn't allow you to, correct?
Correct.
Are you saying that the reason that you don't have any idea about a continuing danger is because of me not letting you talk to her?
No, that's not what I'm saying.
So what you're saying is you don't have any evidence at all, regardless of whether I let you talk to her, of a continuing danger. Isn't that true?
Everything we spoke about was the concern.
Those are concerns, but you don't have any evidence.
Objection non-responsive.
Sustained.
You don't have any evidence that there would be a continuing danger, do you?
This is the evidence of everything we're speaking about.
Objection non-responsive.
Sustained.
It's a yes or no question. Do you have evidence that there would be a continuing danger?
No.
Your attorney talked to you a little bit recently about the drug testing and my client not wanting to do the hair test, but we already talked about her reasoning for that, right?
Yes.
Okay. And it would be normal for a lay person to be concerned about traces of a previous drug being in their hair, wouldn't it?
No, not with that time frame.
Okay. Well, does a lay person understand how drug testing works?
I don't know.
Okay. So if my client doesn't understand how drug testing works, and the only thing she has to go on is what the department tells her, then you could see how she would have a concern about it, can't you? It's reasonable.
No.
Okay, so you don't think it's reasonable for her to have a concern that she should just take what CPS says as that's how it works?
No, I mean, the drug test, the levels should be going down, so there shouldn't be a concern.
But that wasn't explained to her, was it?
It was during the family team meeting.
Okay, in the family team meeting, which was in what month?
Maybe July.
Okay, it was explained about the levels going down.
Yes.
Now, everything in the family team meeting is documented, is that right?
I don't know. I don't document it. I don't facilitate the meetings.
But there is someone facilitating and documenting what people say, correct?
Documenting, yes, but I don't know. That's not what I do.
Well, okay, that's not what I asked you. I asked you, does someone document it? Is the answer to that yes?
Yes, they do document it.
Okay, and then on that family team meeting form that comes out, there's actually, it says like this person's name and then it says what they said, right?
For certain questions or parts of the meeting, yes.
So what questions or parts of the meeting are they per policy to put in the family team meeting paperwork?
The concern of the case, what's been working well with the family, positive strengths, plans for the case, stuff like that. I can't remember each section.
Okay. And you said that drugs are a concern of the case, right?
Yes.
So then if you talk to her about the levels in that family team meeting, wouldn't you expect that to be in the family team report?
No, there's many other things we talked about that doesn't always
Objection, non-responsive after no.
No.
Sustained.
You telling a client that, or a parent, that the levels in the hair will go down. Do you believe that a client should just take that as, oh, okay, no problem, let me go ahead and take a test?
Yes, it would show that they
Objection,
are.
non-responsive after yes.
Yes.
So to you, it's unreasonable for a parent to have any questions about what the department's explanation is. Is that correct?
No.
And she did submit to a urinalysis when requested. That was negative, correct?
Yes.
And you had the opportunity to send her for more urinalysis, didn't you?
Yes.
But you didn't send her for any others since that last one.
The hair follicle, is that what you were talking about?
Aside from the hair follicle, you sent her for the 1 urinalysis, right?
Right.
That's the only other drug test that you sent her for.
Right.
So you understood her concern about something from the past being in there.
Mm-hmm.
You tried, according to your testimony, you tried to explain that the levels would be going down. All right. But you didn't send her for any other UAs to make sure she wasn't using, knowing she had a concern about there still being traces of drugs in the previous hair test.
Correct.
Pass the witness.
All right, thank you, Ms. Iverson.
You don't have any evidence of physical violence in this case, do you?
No.
Witness.
All right, thank you, Ms. McGee.
I have no further questions, Your Honor.
Okay, thank you. Back to you, Ms. Dick.
Okay. Did the mother make an admission to you that there was physical violence in her relationship with the father?
Objection asked and answered.
Objection asked and answered. She just answered that question.
Sustained.
I am, okay.
Sustained.
Basically, the issue is that they're saying there's no evidence. An admission is evidence, correct? I'm asking this.
Objection, Your Honor. This has been asked and answered because there is no admission.
Sustained.
All right. You expressed concern over ongoing family violence previously, correct?
Yeah.
Objection asked and answered. She just stated there's no evidence of family violence.
I'm going to overrule. Go ahead.
All right. You had concerns over ongoing family violence, correct?
Objection asked and answered.
Okay, I just asked it and he overruled it. So
Overruled. You may answer.
Yes.
all right. And what were your concerns based on?
Objection asked and answered.
Do it again. Overruled.
The concerns are based on the mother telling me.
All right. So are you testifying that she told you there was domestic violence?
Yes.
All right. And as far as the ongoing drug use, the mother had just come from a family-based safety services case, correct?
Correct.
To your knowledge, had she done hair follicle tests before?
Objection. Hearsay, she wasn't the worker on that case.
Did the
Overruled.
mother admit that she had done hair follicle tests before?
Yes.
All right. So she was familiar with hair follicle tests, correct?
Yes.
So it's likely that she knew what she was doing when she rejected taking a hair follicle test.
Objection, calls for speculation.
Sustain.
Are issues of drug use and ongoing family violence, do those constitute a continuing danger?
Yes.
All right. No further questions. I'll pass the witness. Thank you.
All right, thank you. Any other questions from anyone for Ms. Johnson?
Yes, sir.
All right.
You stated that the mother told you that there was domestic violence after you stated there was no evidence of domestic violence. When did the mother make this statement to you?
During the joint visit with the family-based safety service worker.
And then didn't she in fact clarify that any domestic violence she had ever experienced was with her ex, not with Mr. Brockman? Do you remember that?
No.
You don't recall that clarification being made?
No, I don't.
Pass the witness.
All right, thank you. Ms. McGee.
No further questions, Your Honor.
Okay, thank you. Any other questions from anyone for Ms. Johnson?
I may, Judge. Can I just have 1 second?
You may.
The conversation that you said was in July with the FBSS worker, was that on July 27th with Rika Aber?
And Ms. Johnson, you're muted, so we didn't get the answer.
Yes.
Okay. So if are you aware that in your impact records that for that July 27th contact, there is nothing about that listed?
I'm not aware of that.
In fact, you haven't made very many
Objection.
into impact since
Hearsay.
Overruled.
In fact,
She's
you haven't
referring
made
to a document that's not in evidence.
I can refer to the document, Jerome. It's the witness.
Overruled. You may answer. Finish the question, please.
In fact, you haven't made very many submissions into impact since this case started, have you?
I don't know how many.
Well, you got the case on the 15th. Is that correct?
I don't remember the exact date.
Do you need to refer to your affidavit?
Thought it was the 16th, but okay.
If your affidavit says the 15th, would you have any reason to say that that was inaccurate?
That would be when the case came in, but that doesn't mean that's when I got the case.
Okay, if you documented an impact that you contacted the reporter on the 15th of June, would that be accurate?
Yeah, it would be accurate if it was in my open investigation notes.
Okay, and so you also recall, well, hold on.
Your Honor.
Are you surprised to know that?
A moment, Ms. Moore, just a moment. Ms. Dick, do you have an objection?
Well, it seems fact's not in evidence. She's referring to the affidavit, and that's not in evidence. And the date that she's giving is not the correct date. I'm just looking at it myself, and it's clearly that she contacted me.
All
You
right,
said that it was the 15th.
let's move along. We're
okay. So on the
very
15th,
close to sawing the sawdust. Let's move on.
On the 15th, when the case came in, you spoke to the reporter. Is that correct? As per your impact submission. You're muted. I'm sorry.
Yes.
Okay. Would you be surprised to know that that's the only thing that you have put in impact for this entire case?
That's not true.
Okay. So if I am looking at records from impact and that's the only thing that I see input by you, then you're saying that that's not accurate.
Yes.
Did you review the impact records before you testified today?
Yes.
Do you have them with you?
No.
The majority of what you're testifying to, you're going from trying to remember what happened all those months ago, right?
Objection, Your Honor. The record is 750 pages.
Overruled, answer that question.
That is the question.
What you're testifying to today, you're going from your memory of what happened several months ago, correct?
And reviewing.
So you're going based off of what you remember. Is that correct or not? I'm sorry, I didn't hear the answer.
Yes.
Okay. There is a possibility that your memory may not be accurate on some of this. Is that correct?
No. Regarding dates, maybe, but not regarding what I'm saying.
Okay. So you've never made a mistake, or you've never confused facts. You've never.
Objection, Your Honor. Counsel is argumentative.
I'm asking a question.
Sustained. Let's move on.
I'll pass the witness.
All right. Any other questions from Ms. Johnson for anyone? All right. May this witness be excused.
Subject to recall.
Subject to recall, yes.
All right. Ms. Johnson, thank you for your time and your assistance. You are excused for now. All right. How many more witnesses does the department have, Ms. Dick?
6 more. And I'm going to ask for a quick recess if we could.